Morning, everyone. Welcome to the Virginia Gas and Oil Board hearing today on July 21st, 2026. Meeting location today is at the Southwest Virginia Community College Auditorium, room B, 150, in Russell County Government Center. Great, we look forward to this. Good, everybody, welcome this morning. Just a couple housekeeping, please. This meeting is being recorded, so please everyone silence your cell phones. If you do need to take a call, please do it outside of the room. And also this morning, I asked the board members that are present here this morning to go ahead and introduce themselves, starting with Mr. Owens.
Patrick Owens, public member, and Mr. Chairman, if you're getting used to hearing by now, I need to declare a conflict on items 5, 6, 7, 8 due to a business relationship with an interested party.
Thank you. My name is Gus Jansen. I'm a public member and also serve as chairman of the board.
Walton Mullins, industry representative, and Mr. Chairman, I would also be abstaining from items 5 through 8 due to a business relationship with enlisted folks.
Mary Dixon, member.
And we also have two board members who are joining us today remotely, and we'll need to have a vote to allow them to participate under the remote attendance. So the first one is Mr. Dennis Sutherland, who is attending remotely due to a family member's medical condition. So I have a motion from the board to approve his remote attendance today.
So moved.
The motion, make a second. All those in favor say aye. Aye. Mr. Sutherland, you're approved to participate today. You ready to introduce yourself?
Yes, Dennis Sutherland, coal representative.
And we also have Mr. Willard Cochran today, who is also participating remotely due to him being 60 miles or more from the meeting location today. Do we have a motion from the board to approve Mr. Cochran's attendance remotely today?
Motion.
Second. Have a motion second. All those in favor, please say aye.
Aye.
Mr. Cochran, you're approved for this face today. Would you like to introduce yourself?
Yes, thank you. Willie Cochran, Virginia Energy member.
Thank you, Mr. Cochran. We also have us joining today. We have two representatives from the Attorney General's office, Ms. Jessica Cooper, and Mr. Sean O'Brien. And we also have several staff members here in attendance at the meeting today. At this time, we'll move on to docket item number 2. The board will receive public comments. Do we have any public comments today, Ms. Gilman?
No, sir.
Having no public comments today, we'll move on to item number 3. Anybody who is participating remotely, please mute your microphone unless you're participating in the proceedings. We have some feedback coming through. And also, when you do participate, if you will turn on your video, that would be appreciated. Item number 3 on the docket today is the First Bank and Trust Company escrow agent for Virginia Gas and Oil Board will appear to address the board on the quarterly report for the period April 2026 through June 2026. We have Ms. Maney here representing the First Bank and Trust.
Good morning.
Good morning. Nice to see you
Nice
today.
to see you. Good to be in person this time. I assume everybody has the PDF version of the presentation. We'll go ahead and get started. We'll start out with the summary on page 3. So this is our second quarter report, covers the time period April to June 2026. The beginning balance starting April 1st was $4,629,728.12. We had deposits for the quarter of $34,471.99. We earned interest for the quarter of $24,900.53. Fees deducted was $4,628.74. Distributions for the quarter were $72,514.83, giving us an ending balance for June 30th of $4,611,957.70. So far in 2026, We have processed 8 regular dockets totaling $94,845.29. We have not processed any treasury dockets so far this year. We've issued over 245 checks that range from 8 cents to $18,273.44. Of those 245 checks, over 160 of those checks were less than $100. The next page is outstanding checks. We have a few of these that will be escheated this year. So anything over a year will be escheated. We have a total of $43,000 that are outstanding at this point, but this goes through June 30th.
What month do you use to do this treatment? Do you use it?
I'm going to use through June 30th. And then it's due probably early fall. Just in case somebody finds a check in their lost mail. So anything up through June 30th, that's a year old, will issue.
Thank you.
Page 6 lists them out individually by gas company. Page 7 is the balance sheet. This lists each individual well with the account number, the unit name, the docket number, the unit operator, beginning balance for June, any deposits received for June, money market interest, Cedars interest, fees taken, any distributions for June, transfers to the No W-9 spreadsheet. We don't have any audit costs, and we haven't for several years. Any corrections issued during the month, and the ending balance for each individual gas well. And then the status of the well. And this is only for the month of June. That goes through page 13. Page 14 is our short No W-9 list now. We have 4 people listed on it, and 3 of those are deceased. So I know the gas companies are working to identify their heirs. We have $901.62 in that account right now. Page 15 is our annual distribution since First Bank and Trust became escrow agent in 2010. So this is all of the royalty and working income received for the years and the distributions that have been paid out each year. Page 16 is where your funds are at as of June 30th. We have about $2.5 million in CDs and a little over $2 million in a money market account. And the CDs are earning anywhere from 3.65 up to 4.20 in interest. So giving us a weighted average for the CDs of 3.95%. Next page, page 17 is our rate comparison. This is a comparison of where we were at the last quarter. We were at a few days ago. And the last page is our CD rate ranges. So I've broken it out by 3 months, 6 months, 9 months, 12 months, 18 months, and 2 years. Does anybody have any questions?
Questions from the board? Just a quick question. For the account listing, I think you may have answered this before, I can't remember. There's a couple of accounts that are listed as Wachovia checking.
Yes.
Can you explain to the board what those are?
So that was money that had transferred over from Wachovia when we first started taking it. Wachovia was a previous escrow agent. And it was a fund that they didn't have an account set up for. I don't know what account to allocate that to, and so we stuck it in a Wachovia checking account. It's been since 2010. It's been a few years.
So those are funds, I guess, that we just couldn't find out which account they went to, so. I'm just thinking out loud here, if there's a way to utilize that funds for anything. I mean, if we do an audit, I guess we could use it for that if we wanted to,
I
or
assume if we had an audit, that
if we had, as we bring forward some of these disbursements where we have underages from an account, is that, did we apply those to make the underage match what should be there?
it could have
That you-
been, it could have been a Wachovia error
Yeah. To
from
correct
years
those.
ago.
that maybe where some of those
It may
areas
be
are coming
somewhere
from.
that is.
That is something we're going to think about in the future when we do disbursements, if that's a way to make those accounts whole,
Yeah.
but and to get rid of this money.
Something to think about.
Something to do with that, so. The other thing, our current investments, I think we've already addressed the CDs that are coming due in July. I think
Yes.
we've already addressed all those that are coming due in July 2026.
So we have, the first two have matured already. The next three will mature tomorrow.
And we've already instructed you to go ahead and reinvest those and see if that.
We had discussed it at the last meeting. I don't know if we made an official.
Yeah, don't vote on that. For this,
Go ahead.
I thought we did too.
If we want, we can go ahead and address that, just to be sure that we've addressed that. We can have some discussion about those funds if we want to go ahead and reinvest those. Another 12-month CD, I think that's what we did the last time.
That is correct.
That's where we've been doing most of the CDs.
Well, just for abundance of caution, I'll make a motion that we do go ahead and reinvest in this 12-month CD.
Okay, so everybody, well, just,
I'll second that.
everyone in favor, say aye. Aye. Those you on the video in agreement?
Yes,
I think I heard Mr. Cochran. Did you hear you, Mr. Sutherland? Are you muted, Mr. Sutherland?
Yeah, I'm muted now. I'm not, I don't think. Yes, I'm about.
Okay. The other thing we may want to consider is that I guess there's been a big decline in disbursements the last, it's like since about 2023. We have a huge investment into a money market that's only earning about 1% this time. We just want to invest more of those funds also with the CD to get a better rate. I think we don't expect any big influx of disbursements over the next year.
Don't anticipate, Kelly might can speak to what she has in store for submitting those, but I don't anticipate. So.
We
We have
have
one
CDs maturing in October and May of next year as well. So we kind of have a CD ladder built.
Is there anything you can add to that, Ms. Berry, that you think we're going to have a lot of disbursements coming in for Pocahontas next year?
I wouldn't say a lot, I work on those as I get time to work on those. And a lot of our constraints are from owners who have not returned W-9 forms.
I think we would probably be comfortable with investing in at least another $1 million into CDs.
That's what I was thinking, because we've never, like you said, historically, going all the way back to,
22.
yeah, in 22, we haven't dispersed that much. And as the lady said, we did have CDs that are coming up. So I think it's only the financially responsible thing to do with, if we wanted to break that up into different CDs.
Under FDIC limits, yeah.
We will make a motion.
Well, do we want to stagger the terms on some of those? Or do we want to stay consistent with 12 months, or you could stagger the terms with those?
And the rates aren't,
The rates aren't
that much different.
drastically different, but I mean, if we're, I was just thinking if we staggered them, like, if you did 4,
6, 9, 12.
or a 6, 9, 12, 18.
Sure.
You want to make that motion? But
You have several CDs coming due, October.
so I'll make a motion that we would take $1 million from the money market account, invest that into 4 $250,000 CDs, one at 6 months, one at 9 months, one at 12, one at 18.
What, you said we've got several coming due in
Got it.
October. What do we got coming due?
You've got 500,000 due in October.
Then what's next?
One is 250 in the end of April, and then 750 in May.
We can continue to, I mean, invest obviously together.
Yeah, I'll second you.
Any further discussion? Motion and second. All those in favor say aye.
Aye.
Motion's carried. Take care of that
All the
today.
best. The ones that are coming due tomorrow, that's another thing.
Anything else, Mr. Lee? Maybe?
All that I have.
Thank you
Anybody have any
again.
other questions?
Everything, thank you. Put together the work here. See you. You months.
3 more months. Got to sleep well, so.
Okay, the next item on the docket is the petition for the Pocahontas Gas LLC for the disbursement of escrow funds to be resolved, deposited with the board's escrow agent, attributable to a portion of tract 1F as depicted on the next table, and the authorization to give payment for royalties directly to Source Creek Land Partnership, 29, Richardson, Elizabeth Bay, Wilson, Carolina Dye, Roll, E. Patton, Caroline and Van, S. Jerry Ralph, Guy, NBC died, unit AC 117, docket number BGOD 11-0419-2930-04. All parties who wish to speak this matter, please come forward and identify yourself.
Mark Swartz and Kelly Berry.
Miss Mary, do you swear
Yes.
and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
I do.
Seeing no other, you may begin, Mr. Schwartz.
Thank you. Kelly, would you state your name for us, please?
Kelly Berry.
Who do you work for?
I work for CNX Gas Company LLC, appearing on behalf of Pocahontas Gas LLC today.
Okay. And did you prepare this petition?
Yes, I did.
Okay. And it concerns what unit?
Unit AZ 117.
And we're seeking three kinds of relief here. First of all, a disbursement from escrow to some specified people, and secondly, an authorization to pay some folks directly in the future rather than escrowing their funds. And last, a dismissal of coal owners. Is that correct?
Yes,
This unit was originally pooled, and we've been tracking payments into the escrow account since it looks like 2011. Is that correct?
yes,
Okay. Going to your petition, in page 2 of that petition, you have a paragraph that deals with the reasons why you're seeking a disbursement, correct?
yes,
Okay, first of all, there's several reasons. First of all, we have a royalty split agreement.
yes, we do.
And have you provided a copy of that agreement at the end of your petition?
Yes,
And what's the percentage agreement? The percent agreed to?
50%.
Okay. And then we also have a proposed disbursement based on House Bill that provided that surface owners would become CBM owners absent proof by a co-owner of a claim, correct?
That's correct.
Okay. And have you listed the owners that would be affected
Yes,
in your application?
yes.
Do you want to extract any name from that list?
We previously had Linda Faye Wilson listed in our group of individuals to be released pursuant to House Bill 2058. However, her mailing was returned and she has now been removed from the petition.
Okay. because she didn't get notice.
That's correct.
Okay. And then with regard to the dismissal issue, you've attached, and this happened a long time ago, but did you attach proof that that Pocahontas, formerly CNX, had notified the coal owner that it had 45 days to provide evidence that it had a coal bed methane claim?
Yes,
And have you attached proof of that notice and also the receipt or acknowledgement of receipt?
yes,
And did you receive within 45 days any evidence from the coal owner in question indicating that they had an agreement or a deed or something to entitle them to make a claim against coal bed methane?
no,
Okay. And so that's the basis for the dismissal.
yes,
Sometimes we have specified amount disbursements and and generally we have percentage disbursements. This time we're dealing with in table 1, which is page number 6 of the PDF. We have a percentage disbursement. Is that correct?
that's correct.
And with the one exception of the person that we are extracting, we'll strike that. Have you provided updated exhibits to Sarah and to the board indicating that we're removing Linda Faye Wilson?
Yes,
Okay, so the board has a new, or at least the division and Sarah have a revised table 1.
yes,
Okay, but the percentages in the table 1 that are in the application that you filed would remain the same for the people that we're actually seeking to disperse to, correct?
that's correct.
Okay, so the percent that the escrow agent should use is in the second column from the right-hand edge of the table, correct?
That's correct.
And the process that the board should direct the escrow agent to follow is it should take the balance on hand on the date that the disbursements are to be made and apply those percentages to get a current accurate dollar amount.
That's correct.
And then that would be the amount of the checks.
Yes,
And we're required to indicate that the wells contributing to the escrow account, which wells are those?
AZ 117 and AZ 117A.
Okay. And then also we're required to provide the board with exhibits that modify the escrow requirements. That would be Exhibit E, correct?
Yes,
So in the event that the board approves these disbursements, you have submitted a revised Exhibit E that would reflect on a going forward basis the people who are in escrow less the people we're paying.
yes, that's correct.
And then in terms of how we're paying people or able to pay people going forward without escrow, you've provided an amended Exhibit EE. Is that correct?
Yes,
And that is like the first page of that. It looks like PDF page number 9.
yes,
Then if we go to PDF page 15, we have an Exhibit J. Tell us what you've done there.
the Exhibit J reconciles our internal records with the records of the escrow bank. If you see an entry that is highlighted in yellow, that means that we have a deposit that doesn't have a corresponding deposit on the escrow bank side.
Okay. And we actually have one of those on the first page.
Yes,
Okay. And then it doesn't, sometimes we have deposits and bank records which can be reviewed and brought into congruence. We don't have any of those issues here. We've just got the one deposit we can't account for.
correct.
And then at the end of your Exhibit J, you have a reconciliation or a comparison of the total that you calculate from our numbers, less disbursements made over the years, and comparing that to the May 2026 First Bank and Trust balance, right?
That's correct.
Okay, and what's the balance? It looks like you're in agreement. What's the balance?
Yes, we are in agreement. The balance is $281.40 as of May 2026.
And as we discussed earlier, you've given the board a copy of the affidavit of mailing to the co-owner, which went out in 2016, and the certification of notice indicating that it was received. I take that back. It must have gone out in 2015 because the
Yes.
co-owner signed for it on June 29th, 2015, correct?
That's correct.
Okay. And then the last thing, we got a copy of the receipt, and then the last thing is the agreement, the royalty split agreement, correct?
Yes.
Okay. Mr. Chairman, I think that's all I have with regard to this item.
Thank you, Ms. Lawrence. Questions from the board? A couple of quick questions, Ms. Mary.
Yes, sir.
The mailing to Linda Faye Wilson, I think you said it was returned.
Yes.
Is that an address? Was it just not picked up, or was it a bad address? Do you have any clue? Have you had any
It was
correspondence with her?
returned, marked as moved, left no address.
So you don't have a current address for that party at this point.
That's correct. So we'll continue trying to locate a good address for her so that she can be included on the next disbursement.
Thank you. And then also, I think you have several parties listed, documentation pending. I think we've seen this lots of times before. So again, these are parties that you've reached out to and you either don't have a W-9 for or a documentation of an heirship.
Right. We're attempting to obtain documentation of the heirs for the individual who is deceased.
That's an ongoing process.
Yes.
Thank you.
Thank you.
Any other questions from the board? Board operates on a motion. Do I have a motion?
I make a motion to approve.
Do you have a second?
Second.
Ms. Gable, will you go ahead and poll the board, please?
Mrs. Gibson,
Yes.
Mr. Mullins,
Yes.
Mr. Owens,
Yes.
Mr. Cochran,
Yes.
Mr. Sutherland,
Yes.
and Mr. Jensen.
Yes. Motion's carried. You have approval for those instructions, Mr. Schwartz. Thank you.
Thank you.
Before we move on to the next item, I'm gonna ask Ms. Cooper or Mr. O'Brien if they would sort of give us, we've had several of our cases involved with the formal hearings that the board's held over the last several months. You could sort of, we haven't met for a while, could you sort of just give everybody on the board an update of what's going on and what the status of those proceedings are at this point? So everybody's
Yes,
aware
sir.
of what's going on.
Yes, sir, Mr. Chairman. So the formal hearing, both of the formal hearing sets of units have been appealed to the Buchanan Circuit Court. The latest batch of unit, the petitions have just reached the circuit court. So those are in the primary stages. If you look further back, the set of units that we did first that we had formal hearings on, those have gone through the motion stage at the Buchanan Circuit Court. And then the Solicitor General's office has filed a motion in the Supreme Court to rule in on the sovereign immunity issue. And we have filed a motion to stay in the circuit court. So effectively, what if the judge grants the motion to stay, effectively the circuit court section will be paused until the Supreme Court can address those sovereign immunity issues. So that's a brief update. And I also wanted to bring to the board's attention something to consider with docket items 5 through 8. So all of these docket items have to do with permits that are associated with that first batch of units that are on appeal in the circuit court. And I wanted the board to be aware that Diversified and Buchanan have previously requested, emergency motions to stay regarding the repooling of these units, and that was granted in the circuit court. And I wanted to let the board know part of the judge's ruling when dealing with these units. So Judge Robertson is the circuit court judge, and she had, as a part of that ruling, ordered explicitly that the status quo for these units is to be maintained in this case. So what that means is that she, by nature of that order, did not want the board doing anything further for these units with regard to the repooling, and she had broadly ordered that the status quo be maintained. So that is something that the board needs to take into consideration with these docket items. I will say there is a provision of the code that requires these types of hearings to be held within 30 days. But we are also at the same time having a circuit court judge tell us very clearly not to touch anything that has to do with these drilling units. So at this point, the way forward, I would seek the input of counsel for Diversified and Buchanan and Pocahontas as to whether we could reach an agreement to continue this past the circuit court decision, so we are not in direct violation of Judge Robertson's order. So I would welcome that input from those attorneys. And in the alternative, if we can't reach an agreement, I think the most cautious way to proceed forward, and my recommendation to the board on these docket items, would be to heed Judge Robertson's order that we not touch anything that has to do with these units and hold these. It'd be my recommendation to hold these docket items in abeyance until the circuit court matters are resolved, and then they have to be heard within 30 days of resolution of that. So at this point, I'd welcome any input from the attorneys from Diversified, Buchanan, and Pocahontas as to whether or not you all would be agreeable to holding them in abeyance and the board considering that just until the circuit court matters are resolved, because I do not want to run afoul of a direct order from a circuit court judge. So I'll open up the floor to the Pocahontas, Diversified, and Buchanan attorneys. I know some of them are there, some of them are online. So,
Okay, this is Mark Schwartz. I definitely would want to respond. Kelly, can you put up the map of the current status of mining in the Coronado mine? I think Sarah may have copies to give to the board. I'm not sure, but in any event, we'll have it up on the screen.
I do not have copies. I didn't receive them, or if I had gotten them before this morning, I would have been able to make copies. I'm sorry. I didn't get your email until after 9.
Okay, no problem. Kelly, what is the date of this map?
The date of this map is July 17th, 2026.
So it's less than a week old, right?
Yes.
Okay, and the longwall panels in the Coronado mine in the rows, the F row and the G row, infecting the F row units and the G row units that we've been talking about now for well over a year. That mining is shaded in gray on the panels, correct?
Yes.
Mr. Chairman,
Yes, sir.
are we discussing the recommendation from the attorney, whether it's, now it sounds like we're hearing evidence and testimony. I think we're getting ahead of ourselves there, but Schwartz has a response to Jessica's question.
I do. I do. This is my response. When, and above what's the panel that they are currently, Coronado is currently mining?
17 East Long Wall.
Okay, and that's the one that's, looks like it's not quite half mined at this point.
That's correct.
And if we go up above, what's the next panel?
Same
That's-
objection, Mr. Chairman.
Hold on just a minute. So we have an objection to you by this background information, which I consider this is background of what you're going to propose to the board
Yes.
here.
Yes,
So
it is.
board
I think you
members,
need-
let's let the board decide whether we want to continue down this. Do I have a motion from the board to allow Mr. Schwartz to continue this discussion?
I'll make that motion.
Do I have a motion? Do I have a second? I'll make the second. All those in favor, say aye. Aye.
Abstain.
Abstain.
Mr. Sutherland, Mr. Cochran? Could you respond?
Yeah, I'm good. I'm good with him to continue.
Mr. Sutherland? You muted, Mr. Sutherland.
How about now?
We got you.
Yes.
Okay, so we're gonna continue on. Well, Mr. Schwartz laid this background for his response.
Mr. Chairman, I will note that we don't have a representative of Coronado here to verify this, so before we get too deep into the woods, come more than background.
Yeah, thank you. You may continue, Mr. Schwartz.
Thank you. Kelly, I think we left off with a discussion or questions pertaining to the panel, at the present time, unmined panel just to the north. And what number is that panel?
18 East.
Okay. And the Oakwood 2 order that this board entered years ago provides that production from unsealed gob gas panels can commence once the panel is isolated. Is that correct?
Yes.
Okay. And does this map indicate that the panel immediately to the north of where Coronado is currently mining has been isolated?
Yes.
And that's because you can see the dark lines, not red lines, but the dark lines all the way around that panel,
Correct.
correct?
Yes.
Who is the operator of all of the units in the F row and the G row affecting that panel, the unmined panel?
Pocahontas Gas.
Either because of voluntary units or because units have been pooled, force pooled by this board, correct?
Yes.
Okay. How many wells does Pocahontas currently have drilled in the F and G rows affecting this panel that's about to be mined?
I'd have to pull that information up.
Go ahead and do that.
Are you referring to the 17 East or the 18 East, Mr. Schwartz?
I'm referring to the 18 East and 19. But my question to Kelly at this moment is with regard to 19 East, how many wells does Pocahontas currently have drilled in that panel? Or yes, in that panel.
That would be in 17 East. I'm sorry.
No, in the 18 East panel, okay? And the 19 East panel. How many wells, just cover both of them, how many wells does Pocahontas currently have?
16 sites are laid out in 18 East. 9 of those are built. 1 is under construction. And we have 1, 2, 3, 4, 5 sites that we have permits issued for, but they are currently involved in the units that are under appeal.
Looks like that you have a total of 2, 4, 6, 8, 9 permits issued for the G row. Is that correct?
In 18 East?
Yes.
Yes.
And 2 of those G row permits are on the docket today as appealed, correct?
Yes.
Okay. Now, in the F row, also affecting the east panel, how many issued permits do you have?
2.
Okay. And how many have you submitted that have not been issued yet?
3.
Okay. And is one of those 3 permits on the docket today, the F37A?
Yes.
Okay. In the 19 East panel with regard to the F row, how many permits do you have issued?
In regards to the F row, 4.
Okay. And how many well locations have you laid out in the F row in addition?
6.
Now, these permits, the ones that have been issued and the ones that the sites have been laid out or the permits have been applied for and are on appeal here, these are all what are called degas wells, correct?
That's correct.
And by that, it means there is degasification of the coal before, during, and after mining to promote mine safety, correct?
Yes.
Okay. If the board does not consider these appeals, we're going to have at least 3 wells that should be operating to degas that will not be operating to degas this panel in advance of Coronado's mining, correct?
That's correct.
Based on the estimates that we've heard from our folks with regard to the range of gas to be produced from these panels, we have been talking about somewhere between 9 million and 13 million cubic feet, correct?
Yes.
What is going to happen in advance of mining and the continuation of mining here if CNX is not, or Pocahontas is not allowed to produce the wells that it has permits for and is not allowed to pursue additional permits with regard to degassing this coal in advance of longwall mining?
That would have an impact on mining operations.
Okay. Well, if Coronado wants to continue to mine, do they have an option?
Yes, they can permit vertical ventilation holes.
Okay. And who permits vertical ventilation holes? Is it the Division of Gas and Oil or is it somebody else?
It's the Division of Gas and Oil. The
And-
vertical
and-
ventilation holes. Would they be permitted by the Department of Mines?
Department of Mines would permit those.
Yeah.
And
So, Mr.
what
Chairman,
happens to
just an
gas?
objection
What
here. We're basically
happened-
having a quick examination, which has not been authorized. This document, there's been no foundation laid for it. Coronado has not been asked to speak to it. And we're also apparently soliciting potential expert testimony from Ms. Berry. So I just need to note an objection to all of this that's gone on over these past 15 minutes and moving forward.
Ms. Berry is an expert. What happens to gas from vertical ventilation holes?
We get it.
Hold up there, Mr. Schwartz. We're gonna have to rule on this latest objection.
But also the witness has sworn if she's not a witness, this is just,
This is
That's the problem.
argument. You know, here's the problem. And I'll
never seen
just
an
sum-
argument like this.
I'll withdraw that
We
question.
never-
I will withdraw that question and I will make this statement. If Pocahontas Gas, who is the operator of every unit in the G row and the F row, is not allowed to produce gas from wells in those rows, is not allowed to permit the wells that Coronado needs to degas in advance of mining, Coronado will be permitting and drilling vertical ventilation holes. It will then vent millions of cubic feet of gas into the atmosphere, and it will be wasted. And the royalty owners, the companies and people who own tracts within the G row and the F row will never recover royalties on that gas that is wasted. In addition, people who could have or do have a working interest in those pooled units will be denied revenue from the gas that is wasted. So a decision to just say, we're not going to issue permits here, or we're going to stay production here, is going to cause the board to essentially violate the reason it was created, to prevent waste and protect correlative rights. I will also point out that the board doesn't issue permits. The Division of Gas and Oil issues permits. And under the provisions of the 3 articles of the Oil and Gas Act, it's perfectly clear that the director is in charge of issuing permits. The Division of Gas and Oil is not a party to these proceedings in circuit court. There's no relief sought against them. There are no complaints made about their permits. The Division of Gas and Oil can continue, in my judgment, can continue to issue permits because it's not the board. It doesn't have a stay order requiring it not to issue permits. So, I mean, the net effect of a decision to not consider these appeals of permits issued or deferred by the division, and a decision to not permit, well, it sounds like the board is saying to the division, you can't issue permits going forward. I mean, I'm not sure that that's intended here, but this is a huge issue with incredible potential negative impacts. First of all, it's going to impact Coronado's mining. Because mine safety is paramount. They need to degas this coal. We have permits in place, sites built. We are moving forward with this. We're the operator of every one of these units, and we need to be able to degas these panels to facilitate safe mining. If we're not allowed to do that, Coronado is going to have to come in to safely mine this coal and drill vertical ventilation holes. Whether or not that's going to delay mining, put miners out of work, I don't know the answer to that, but I do know it will waste hundreds of millions of of cubic feet of gas from these units. So a decision to not hear these appeals today has horrendous ramifications. So that's my objection.
Thank you, Mr. Schwartz.
Mr. Chairman, may I make a brief statement?
Yes, I will have you all respond to Mr. Schwartz.
My response is to be brief.
Who wants to go first?
I think the Pocahontas request to the board is unfair to the board, because it puts the board at cross purposes to the court's order. All of these arguments that have been made can be made to the circuit. Then she can modify her order, and the board's not put in jeopardy of interfering. So that's my thoughts.
Can you speak to, or do we have a representative from Coronado who can speak to the timing of what's going to take place in the circuit court versus the timing that needs to happen for these wells to be in place prior to the mining?
Well, both parties have presented arguments to the court on emergency here. We've got another one tomorrow. So I don't think that putting the board in jeopardy is interfering with the circuit court's jurisdiction is necessary. Go before the circuit court with these arguments. She made the rule. She can untie any restrictions she puts on the board.
In response to the chairman's question of timing, we have an August 1st deadline from Coronado to demonstrate to them that we are likely to be able to obtain the permits we need to do the degas wells that they need. August 1st. That is, 9 or 10 days from now. And the upshot of that is, if we can't provide them with reasonable assurance, they're going to proceed with the vertical ventilation holes and waste all this gas. Usually there is someone from Coronado on these calls. I hope there is right now, and I welcome them to chime in, but we have been given that deadline, August 1st. So going to the circuit court, doing all kinds of stuff, when it's the division of gas and oil that we're talking about and not the board, is not going to cut it here.
I believe we have Mr. Sean Lundy on the line, on the call today also, representing Coronado. Would you have anything you would like to add to the conversation?
What Mr. Schwartz said is true, Your Honor. Your Honor. That's the deadline.
Do you have anything you want to add, Mr. Street?
I doubt what Mr. Pruitt said, but the irony, there's some irony here, Mr. Chairman. That is, while they're telling you that they need to brush and get the wells in, what they're telling the circuit court judge is stay everything. We don't want to have a trial in circuit court to try to determine who the operator of the unit should be. That's the issue with the circuit court right now. Right now, we have a de novo. It's a brand new trial set for early next year. The purpose of which is to hear our objections, and make a decision about who should be the operator of these two, 737 and G37. That's a fresh start before the circuit court. Circuit court judge is going to make that determination. And once that happens, if the Pocahontas gas prevails, then they can put wells there. If we prevail, if Diversify prevails, we get to put wells. That's where we are. We're in state courts. Judge Reese Robertson is going to make that decision. And for this board now to, even for Pocahontas now, try to jump the gun and get wells in place on the ground, in the face of Judge Robertson's order saying, I'm gonna handle this. The board doesn't handle this. I see problems. Yeah, what they want to do is they want to get a $750,000 well installed on a unit that Judge Robertson may find in 6 to 7 months is a unit that belongs to us. Imagine where that would put us. Does that present complexities? It does. I mean, this whole case is full of complexities. But that's where you guys are. That's where we are. I thought I heard Mr. Forbes say the Department of Energy is not a party to that case. I don't. I disagree with him 100%. They have made an appearance. They have filed pleadings. The Attorney General has entered a appearance on their behalf and signed orders on it. So that's just not true. You know, this is where we are. You know, unfortunately for Mr. Schwartz, and I think your attorney has given you the proper advice. I've disagreed with her advice before, and I think y'all have been consistent in selecting her advice over mine every time. And that's probably where you are today. I have to accept her advice. Pocahontas gas is lawyer and there are ways to get the judge and circuit court to rule quickly, which is what we want. We want a quick ruling in circuit court before Judge Reese. But the problem, you know, what's happening that they're not telling you is they're going to Judge Robertson tomorrow and saying, Judge Robertson, we don't want to have a trial. We want to put everything on pause till the Supreme Court rules and that could be illegal. So they're Mr. Schwartz, I'm telling you one thing.
You're characterizing this emergency hearing tomorrow as in one line. I'm not sure if Mr. Schwartz would agree with your characterization, so I'll ask him in a minute. If his, what the emergency, I'm trying to understand what this emergency hearing tomorrow is about.
Yeah. There's a question about it. I can tell you what we have scheduled here, and that is simply have the court enter a stay on the election period that we have. You know, we have an election period under the pool. And so we've asked the court to stay that period so we don't have to make an election so it won't be used against us. So that's set for this.
That's what you had the same type of hearing back in December, I
Yes,
think.
sir. That's correct.
And the judge didn't give you that stay at the time. They moved forward. You agreed to go ahead and make an election, I think, at that time.
No, that's not exactly right. The judge encouraged all the parties present to enter into agreed stipulations.
There was stipulation, I think.
So that's how we handle it. But then since Friday, I think Pocahontas Gas is trying to add on hearings for tomorrow to get the judge to stay everything, which would in effect postpone the trial and would delay a determination by the operator. We would like to go ahead and keep that process going so we can get to a decision from the court as soon as possible to head off or to minimize these issues. But that's not the approach Pocahontas Gas is taking in circuit. They're trying to delay that.
Mr. Schwartz, you want to respond to that
Yes.
characterization that runs in the hearing?
Yes. I've heard some pretty amazing things from Diversified in the last year or two, but I just heard one that really tops them all. I think I just heard Mr. Street say that we are in circuit court asking the circuit court to stay permitting and production from degas wells. Quote, he said, we are in circuit court seeking to have the circuit court stay everything. Seriously, we're here today because we need to be able to produce these wells, to degas this mine for the safety of the miners so Coronado can proceed. The suggestion that we are in circuit court saying the opposite is crazy. We are not in circuit court seeking to stay permitting or production from wells that are in units that we are the operator of. We are absolutely not doing that. Now, if you don't make a decision today on these appeals, your next meeting is a month from now. Our deadline is August 1st from Coronado. Mr. Lundy has just confirmed that. We need a decision today because your next meeting is too late for us. That's my response.
So can we get an agreement between all the parties today that there is a time-sensitive issue here regarding the degas in these wells? Is that what I'm hearing, that if we don't make a decision today or within a very short time frame here, that the only option left for Coronado is to proceed down the route of vertical ventilation degas wells where the gas will be wasted? And all this will be mute in April of 2026. Is that not true?
I can't answer that, but maybe Mr. Lundy can. I don't know what Coronado's deadlines are in terms of, you can put degas wells in and convert them over to production wells pretty quickly. I don't know the timelines on that. I don't know.
Back to my original point, Mr. Chairman, I think that any agreement between council should be before the circuit court. She's the one that has made this ruling and laid down this state. And there's no reason in the world why the parties can't go before her with an agreement. It's unfair to this board, put this board in jeopardy. So
Every time the diversified and Buchanan people want to avoid something, they say, let's reach an agreement. We never reach agreements. We have been negotiating a commercial agreement with them for 2 years. Okay. The idea that there's going to be a sea change tomorrow and we're going to negotiate, we need a decision. We have a deadline from Coronado. As far as we can tell, they're not kidding. I mean, they have a huge mining operation at significant investments and obligations at stake here. And they've told us, let us know by August 1 or we're going off and doing it ourselves. The trial of the circuit court case, I believe, is set for April of next year. The mining in the next panel to the north is scheduled at the present time to begin in November. We don't have time to wait for a trial in April of 2027 to degas a longwall panel that we're currently mining and to start degassing a longwall panel that's going to be mined in November. I mean, this is urgent.
Any further response to what Mr. Schwartz is?
We noticed the appeal on to try to get the circuit court passed. Remember, Pocahontas Gas is still not following answer. They have done everything they can to delay that circuit court proceeding. And so when he comes in here now and claims, oh, we're in a big rush, I hope you'll take that with a grain of salt, because what they're doing is they're in circuit court trying to delay the trial, postpone, drag it out. In the meantime, utilize this board to go ahead and get wells in the ground producing, so that by the time the circuit court ever reaches it, that's their time. And I'm asking you not to participate in that, because we have tried to get this thing set for trial. We can't get an answer. They're asking to stay the whole case in circuit court, Supreme Court, all while they're before you today trying to urge you to basically do something that is going to interfere with what the circuit court judges said, which is the circuit court judgment should be the operator. For this board then to sanction the installation of wells on property that she hasn't ruled on, it's just procedurally not possible. That's the problem. So they do have, I mean, Mr. Privett's right. If this is an issue, they can go back to the judge right now and ask reconsideration court and modify the prior order. They can call the court on a witness. They can do a lot of things, but they don't want to go there. They want to use you guys. They want to string that one out. They want to accelerate this one. They want to change the parties, and that's just not a kosher method. Particularly since the marriage is already ruined. So
I think that Ms. Cooper can back me up on this. The reason the trial is in April of 2027 is because Diversified wants to do tons of discovery, and it's going to take months for that. They don't want to proceed on the record that we made in front of you all. They want to start over, do all this discovery that we've done over and over and over again. So for them to come in here and suggest that we're pushing the circuit court case down the road, we wanted a de novo appeal hearing that the statute provides. They want discovery. They want to turn this into a three-ring circus. And the reason we can't have a trial until April is because of them, not us.
Mr. Chairman, I do have a suggestion on number 5, which is F37A that might be helpful. There was a revised application submitted to the director by Pocahontas for that. We've noted objections. I believe McLean County had as well. And I believe the director has resolved the one set of objections by the county, but we've not been notified of any informal fact-finding conference or hearing with the director for that revised application to go forward. We do have an appeal of the director's decision on the original application that's before you today. We'd be willing to go forward on that one and get a decision from the board on that one. But there is a pending F37 application before the director. Our objections have yet to be heard. It probably makes sense for that process to proceed. And that way, if there is an appeal noted from that decision, the board can take that up alongside the 2 G37 appeals.
Ms. Cooper, I'm gonna lean on you for a little direction here. I've heard some arguments that state that the court's stay at this point in time does not apply to the permitting process side of Division of Gas and Oil. I'm not sure if you have an opinion on that at this point in time.
You're muted.
Darn. Okay. Judge Robertson's words were to maintain the status quo in relation to these units. And we are in a difficult situation. The board's in a difficult situation because there could potentially be wastage, or there could potentially be putting new wells on these units, which is development. It's not maintaining the status quo. So at this point, I think the safest way forward to maintain the status quo, at least for the temporary future, and perhaps Pocahontas can, get some clarification from the circuit court on this, but is to not rule on this, because Judge Robertson has made an explicit order that we need to maintain everything. And for the board to rule on something that is contrary to a circuit court judge's direct order is not a good situation. And we want to obey the court's previous order with relation to these units. So, I mean, the options going forward, if the board did that, was, Pocahontas could approach circuit court and ask for clarification on her previous order if this extends to permitting. Right now, from what we have based on the record, it extends to every situation touching these units. And I will say, with the argument that the division that permits is not the board, yes, the division is not the board, but there is a mechanism where the director's decisions are appealed through the board for the permit unit. So that then becomes board business, and the board is the one named in all of these suits. So that's my final advice going forward. That's the safest option. It's a hard situation, and it honestly needs further clarification from a circuit court.
So that was going to be my next question, Ms. Cooper. If this emergency hearing tomorrow gives some clarification to the board on how to proceed. There's nothing to prevent this board from reconvening under an emergency meeting and hearing these permitting issues, if that's what needs to happen.
If I believe
To meet this
notice
August 1st
requirements-
deadline that we've heard today.
I believe notice requirements would be the only thing. So as long as everyone has enough time pursuant to the notice requirements, I think that we could have an emergency meeting on that if we needed to, as long as there was enough notice given to everyone.
Yeah, could the parties involved here today waive that notice?
See, I'm not familiar with the notice requirements for permitting because I don't usually deal with them. So I'll lean on y'all a bit here, especially Mr. Skarupa. Mr. Skarupa, are landowners typically notice? I'm looking it up right now, but are landowners typically noticed for the permit side of things?
Yes.
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 Yeah. But here's the, if to take Gus's suggestion, you could continue this here. I don't like where this is headed, but let me answer something or suggest an answer. If you continued this issue to 3 days from now in open hearing, that would be noticed to everybody. If it's just like we have something on the docket and we continue it to the next month. We don't send out new notices. And I think you could accomplish that. Jessica, I asked you to weigh in on that, but I think that might be a way to solve the notice issue.
As long as everyone was properly noticed for the previous hearing, I think that could suffice in a pinch. I'm looking up right now in the section for permitting regarding notice. So,
People who've been noticed in the permit already, this is a completely separate transaction, or whatever you want to call it, from what's the permit is going on, what's been appealed to the board. This notice is for the board. This is not notice for the actual permit itself, correct?
Correct.
You've been notified that the permit's been submitted.
Right, the board has already notified everybody of this hearing today, so that should satisfy the notice requirement.
I believe if we make a note of notice on the record, that should be sufficient in a pinch. Please bear with me as I'm looking at the code. I mean, I think that could suffice if all parties here agree. I don't like getting in the habit of doing that, but if all attorneys here agree that that is how we could proceed in this case, I think that's a viable way forward.
Since it was my suggestion, you can assume I'm in agreement.
Can I ask a question?
Yes.
This would only matter if the circuit court judge tomorrow or whenever provides us with new information or new direction, right? I mean, if it stays the
Yes,
same,
that would be before we continue this hearing, before we make a motion to continue this hearing, that would probably be part of the motion that we would only need to reconvene if we were given clear direction from the court tomorrow as how we should proceed.
Okay.
If there's no clear direction there, then there's no point to convene again. We'll just, we can make that a stipulation of the continuance, and they'll just be continued until the court decides that we are clear to move forward.
Okay, thank you.
That sound reasonable to everyone here? We sort of have an option depending on what comes out of your emergency hearing tomorrow, the issues, whether the judge will even allow, I don't know, all these issues are what the judge was intending to hear tomorrow. So, if the judge doesn't choose to hear them, then we have no resolution, then everything just continues, and we could have, that would be the motion by this board, we would either continue. We can set a date today if we want to, until such a date, or if the court rules in one way, and if the court rules the other way, we'll just move down the continuance of the fourth clear side.
I think though, you need to pick a date today though, that if, depending on what the court does, we would come back or not come back. I think it needs to be on the record during this meeting what the date is.
Yes, we would need a date for, especially for the notice requirement to landowners.
Why don't you just, well, here's another option. FOIA lets you have a meeting with 3 days of notice, right? Just basis. I think that's right. So why don't we see what, if anything, the court does tomorrow or in the next week or two, let's consider this on a separate time. And you can do a 3-day special call meeting. And I'll tell you, I don't have any vacation plans, so I'm wide open. I'll accommodate you however I can.
I'm sorry, but I think we need to pick a date today before August 1st. Depending on what the court does.
Mr. Lundy, are you listening right now? This deadline that Mr. Schwartz talked about, end of July, is that something that has some flexibility? I know you probably can't agree on anything today without talking to your client, but is that something that's like hard and fast, or could that be pushed back to like the 15th or 14th?
Can everyone hear me?
Yes.
Okay, sorry, it shows me not mute. Okay, sorry, everybody, I would be where you can see me, but I'm actually driving and listening to the hearing. What I'd say is there's no doubt that, you know, the deadline that Mr. Schwartz said the company gave, and that is the deadline that the Corno did give Pocahontas Gas. You know, I can't speak for them without asking. My thought is that there would probably be some leeway if we were only talking about a few days.
Let me ask the board members that are present here today and on the call, does anyone have any restrictions over the next week or two? Get back together, whether it's in person or we do it as I guess we can do a video call, so we can met today if we need to.
It's according to which days you choose. I do have some obligations.
You need to share those with us.
I have an obligation on the 24th, 27th, and the 30th right now. But there is a possibility of another emergency type appointment. But I won't know that until I have a contact.
Any other board members that have conflicts? We need to be aware of, to make sure we be able to have a quorum, I guess. I'm out on the 30th.
I'm available, so I will be here to abstain whenever.
Mr. Crocker, Mr. Sutherland, anybody?
If it's on the 29th, I would have to do Zoom again, I guess.
Actually, this is Mark. My wife has surgery on the 29th, so I know I can't be available on the 29th, but she should be in and out that day, so I could be available the day before or the day after.
Yeah, we go to the 27th to 28th, that works for everybody at this point.
Yes, 27th does not work for me. But
28th is a possibility, I guess, for everybody. Is that true? Yes.
Works for me.
Ms. Cooper? Is that a problem?
Yes,
You
that
your
works for
office?
me. I'm wide open on the 28th right now.
Okay, is there any other discussion we need to have before we have a motion?
Mr. Chairman, would that potentially be at 10 a.m. normal time?
That works for me, if that works for everybody else, would be at the same time.
If it's gonna be productive, it's probably gonna be a long day. You can start earlier.
I have a mediation that morning at 9, but it'll be over at noon. So start at 1. Or noon, start at noon.
Okay, are there dates in addition to the 27th and 28th that we kind of need to keep open?
I think right now, we're sort of hanging in on the 28th. It's the,
Okay,
date right now, maybe at 1 p.m.
1 p.m.
Okay.
Yeah, that's right.
We have,
We
I'll have to check and see if it's available.
if not, we can always defer to a video meeting if we need to.
That's next Tuesday.
So then we will try to make this motion. We'll try to make.
I'll make a motion. We have the emergency meeting, 28th.
And that motion would include the language that confirms whether the court gives us clear direction before we have a meeting and gives us the option to not have a meeting if the court rules that we are not to proceed at all.
Okay. Can you include that in that?
We have a motion, do we have a second? I'll second that motion. So we're going today, take a vote on this motion, Ms. Gilman, and then I'll continue each of those items.
Mrs. Gibson,
Yes.
Mr. Mullins,
Abstain.
Mr. Owens,
Stay.
Mr. Sutherland.
sorry, let me hear the motion again.
Mr. Sutherland, we're making the motion basically that we're going to continue this hearing until Tuesday, the 28th at 1 p.m. In the event that the circuit court provides us with some clear direction on whether we can hear these 4 docket items related to the permit appeals. And if the court gives us no clear direction, then we will not meet. We will just, these will be continued indefinitely until the court gives us clearance to do that.
Okay, I'm yes on that.
Thank you.
And Mr. Jansen.
Yes.
Oh, did I get Mr. Cochran? Mr. Cochran,
Yes.
Okay, that motion is carried. So I'm gonna go ahead and read in the 4 docket items and then ask for a motion to continue those for the motion we just made. So we have a petition for the Division of Gas and Oil on behalf of others for First Fire Production LLC appealing the decision of the director issued on 3-33/2026, objection number 77 regarding application number 64170 for Pocahontas Gas LLC for proposed well CBN F37A located in the Garden Magisterial District, Cannon County, Virginia, docket number BGOB 26-616-4336. We'll also call a petition from the Division of Gas and Oil on behalf of Cannon Energy Company LLC, James O. Bunn, the second manager, appealing the decision of the director issued on 3-3/2026. Objection number 78 regarding application number 64170 for Pocahontas Gas LLC for proposed well CBN F37A located in the Garden Magisterial District, Cannon County, Virginia, docket number BGOB 26-616-0327. Also, a petition for the Division of Gas and Oil half voters for Diversified Production LLC, billing decision of the director issued on 3-3/2076. For objection number 79 regarding application number 64222, Pocahontas Gas LLC for proposed well CBN G37B located in the Garden Magisterial District, Benton County, within the docket number BGOB 26-616-4328. Finally, a petition from the Division of Gas and Oil on behalf of others for Diversified Production LLC, billing decision of the director issued on 3-2026 for objection number 80 regarding application number 64223 to Pocahontas Gas LLC for proposed wells CBN G37C located in the Garden Magisterial District, Benton County, Virginia, docket number BGOB 26-616-4329. No motion from the board to continue these 4 docket items as to the prior discussion we have. We're going to continue this meeting. That second. I'll second that motion. We hold the board. Gilmore.
Mrs. Gibson,
Yes.
Mr. Mullins,
Abstain.
Mr. Owens,
Abstain.
Mr. Sutherland,
Yes.
Mr. Cochran,
Yes.
and Mr. Jameson.
Yes. Motion carried. So we'll continue these items. Depending on the outcome, the circuit court motion period until tomorrow. We will see you next week for lunch.
No offense to the spine board, I hope we don't see me next week.
The next item on the agenda today is the board receiving an update from the board and commission activities from the staff. Before I hear the board's, or the staff's activities there, I did want to take a moment to recognize Mr. Bill Harris, who has been a longtime member of this board. He served for 24 years on this board before he elected not to continue on due to health concerns he has. I know that the department's going to recognize Mr. Harris at some point in the future with a little token of the appreciation from this board. But I just wanted to thank all the board members here, and Mr. Harris has been a good advocate for this board for many years and has been served very well. He does a great job for this board in this time of service. So we do appreciate this effort so many years. Wow. Wish him the best. Anything from the board today?
As far as next month, we have 3 items on the agenda for the regular discussion.
So maybe an emergency meeting, but not no meeting in August at this point. So I did have one question for you, Mr. Cooper, if you could maybe chime in on. I know there's the combined methane capture and utilization program that's been out there by the department right now. Could you maybe just give the board a little bit of background on that and where that status of that grant proposals that going on right now, just so we can, how it may affect the activity of this board?
Well, there's $79 million. Well, that with proposals, and Lydia might help answer some of the questions. I don't think in the real fine details.
Yeah, just a high level, just of how that may, and we think that will have any impact on production in the field, and will have any impact on this board's work that you're going forward.
Eventually, yes.
Do you have any questions for the staff today? Okay, the next item on the board is to review the May 2026 minutes for approval. Please everybody provide a copy of those. Has any corrections or comments on those minutes?
Motion approved.
Second. The motion is second. We'll do a voice vote. All those in favor say aye. Minutes are approved. This meeting will now be adjourned. Thank you very much, everybody.
Thank you.